Oh, I'm Terry Loomis Therian. I've been practicing law for umpteen million years, it feels like. I was speaking to an associate, another attorney, and I was like, felt like I'd practiced a long time. He was a 50-year, and I'm like, wow. But I've been at it for 35, and I'm still going, so it's fun, though. I like working with associations. I wanted to talk about a little bit about the two new statutory changes. There's been others, but these are the interesting, hot ones, fun ones. One of them is the virtual meeting. A couple of years ago, probably 2013-ish, we had the Open Meeting Act, which then got rid of the cowboy world of just holding your meetings whenever you wanted to, and it had agenda requirements and what you can and can't talk about at a meeting if it didn't end up on the agenda, and getting notice out to the members. It just made everything a lot more transparent to members, and it tightened things up. So now we move into COVID. And during COVID, it was like, oh, we can't hold meetings anymore because we can't get a couple of us together anymore. So virtual meetings started. And it was a free-for-all in that respect. It was just everybody signing on. A lot of new technology came out, and it was permitted. It was an emergency. Then the governor came back and said, okay, we're no longer in an emergency. The statute's changing. We're going back to what we used to do, and that is you have to have board meetings, give them notice, homeowners get to come. Well, everybody kind of in the industry said, no, we're not going to do that. We're going to keep doing virtual. And it was really kind of funny. Some of the seminars, you'd see a lot of property managers show up, and they're like, we're not doing it. We're going to do virtual. And well, the law is back to what it was. We no longer have emergency circumstances. You have to give notice and hold regular board meetings where people can attend. No, we're not going to do it. So finally the law has changed, and now we can do virtual meetings. It can be a full virtual meeting. Previously, you had this quasi kind of virtual meeting where you had to have a location and somebody there at the meeting who could run the virtual and allow people to talk at the meeting or to hear people on the virtual, on the screens or the computers. And that's just almost impossible. Hybrid meetings are or some people want to do hybrids. The problem with a hybrid is if this is your computer and you have people coming in virtually, how are those people going to hear you folks that are at the meeting unless you turn the screen to them? Okay, so hybrids are very difficult because it's hard for everybody to participate. If you have a lot of technology like cameras and mics and speakers, you can do that. But it's better to either choose to do in person or totally virtual. Don't try to do a hybrid between the two. One of the other new laws that's really entertaining right now is quorum requirements. So how many of you guys have quorum requirements, and if you have like a 50% or 51% quorum requirement for membership meeting to hold your votes, you can't meet it. Some CC&Rs will allow you to go down to maybe 25%, 20%. Some of them have them. There's a lot of them out there that don't have that. Well, we have the new amendments to the Civil Code and the Corporations Code now that says, for those of you that don't have a reduced quorum permission in your governing documents, you get to go down to 20% now too at your adjourned meeting. So it's not the first board meeting, first election meeting that you call to order. It's when you can't make your quorum and you adjourn to the next meeting, then you can just go down to the 20%. There's a couple of requirements that's necessary. And first off, the adjourned meeting has to be at least 20 days out. So remember how you try to adjourn it maybe to 5 days or 10 days or something like that? You have to go out at least 20 days. Additionally, there's a notice requirement somewhere in 15 days or more. You have to let everybody know that you're adjourning to this date and tell them the date, the time, and the place. And you have to tell them the list of candidates. And you have to say, we're doing the reduced quorum of 20%. The good thing is that doesn't have to be a mail notice. That's just a general notice. So like you post your general notices out on the bulletin board saying we're having a board meeting next Thursday night or on the second Tuesday of every month, you can post this 15-day notice that's required for reduced quorum. Okay, so Pardon me? You can email too, but there is the general process by which you normally give general notice. If it's by posting, you do email blasts, but you have to have a place for people to get this information. So if you send out a newsletter every year, every month rather, to say, okay, don't forget to come to your board meeting, you probably also post too, okay? Or you have a portal that people can go up on. But again, that's your general notice. You're not required to do a mailing. So that makes this really functional. Let's go ahead and talk about for a few minutes the fiduciary duties of your board of directors. You have two basic duties that are fiduciary. You have your duty of care and your duty of loyalty. The duty of care is your best business judgment rule in all essence. What are the 4 things that you have to make sure you do as a board member when exercising that duty of care? You have to act in good faith. In other words, you can't ignore a problem. You can't just pretend it doesn't exist. You can't say, oh, we don't like Joe, so we're not going to fix his roof. Okay, you have to act in good faith. You also have to act in the best interest of the community, of the whole association. Not just one person, not just a group of people, but you have to act in the best interest of the entire association, okay? Additionally, you have to exercise reasonable inquiry. That means, let's say you have some trees that are not, don't look really good. And you're like, well, we must have some fungus or a virus, or there's something wrong with the trees. I think we should cut them down. Are you an arborist? Can you make that decision? Should you be making that decision? No. If you really know you have a dead tree there, it's obvious, yeah, let's don't be silly about it, okay? But if you've got a tree that you're not really sure is functioning, it's got a problem, get it checked out. At the same token, you got people saying, oh, we got these trees over here, but we don't like them, we want to get rid of them. Is that necessarily in the best interest of the community? You're thinking about what you like, not what's in the best interest of the community. Okay? You also have to act as a prudent person would in a similar situation. Okay? So if the roof's leaking and you say, well, screw it, we're not going to meet till next May 3rd, okay? A reasonable prudent person doesn't put off fixing a roof while we're in these rains. Okay? So those are the 4 things you have to do as board members to make sure you exercise your duty of care. This is your best business judgment rule. It's all interrelated. One of the important things to remember is this is not only some duty. Don't think of it like you're carrying this burden around on your shoulders. This is a shield to protect you. About 15 years ago, we had a month-long trial where a homeowner was suing the board and the association about different slope maintenance things that were taking place. And the board had made business decisions. Not all of them were correct decisions. They did the best they could. They came up with a game plan and tried to implement it as best they could. This other person didn't agree, so sued the association, sued the board members for making this decision. After a month of trial, it's really cool, after a month of trial, the judge actually picked up the corporation's code that sets forth your duty of care, which is basically the best business judgment rule, and said they exercised their duty of care. The board and the association is not liable. They did their best job they could. The judge read it into the minutes and everybody in the courtroom. It was really cool. Granted, it took a month's worth of trial to get there, but so it works. So when you do this, look at it in terms of this is a shield that you guys are carrying that's good for you as a board member. It really does work. I'm not very good here at moving the talked about that. Here we go. The duty of loyalty. This is an interesting one. This means no self-serving, no self-interest come before the association's interest. When you're wearing your board hat, you think in terms, I'm at a board meeting, I'm wearing my board hat, I take it off, I put it down, I go out, and I'm a homeowner now. Well, that's true until you start making decisions or talking about things that need to be done. For example, your neighbor calls you up and you say, doesn't your son own a roofing company? And you're like, yeah, but that's nothing to do with me. I'm a board member, and I don't have any profit off my son's roofing company. Well, isn't your son doing roofing for us in the association? All of a sudden, you have a perceived problem with self-interest, don't you? A conflict. And when something like that comes up, you need to be open and honest with the membership about it and your board. And you should recuse yourself for decision making so that the board can say, we like this as a good roofer or not a good roofer, and you basically sit there and keep your mouth shut. But your duty of loyalty means that you can't look after you or your family's interests first and above your board position, okay, and your duty to the community. You have to exercise your duties to the community first and foremost. If you can't do it, you have to recuse yourself and not be part of that process. Your duty of loyalty also means you need to show up to board meetings and make decisions. How many do you have those? How many of you have board members possibly that don't show up? Okay, they are on the roster and they just, you know, they know the board meeting dates, they know they're supposed to be there, and they don't show up. They're breaching their duty of loyalty.
What can an association do or a board do in a situation like that?
You'll have to speak to your general counsel about that. There's all kinds of things that can be done. I mean, sometimes just go knocking on somebody's door and say, look, you're on the board, but you never show up. Can you at least step down so that we can get somebody else in to help us because we need to make quorum. We don't have enough board members anyway. Sometimes that doesn't work, and then, so sometimes you have to take other actions. Sometimes your governing documents will allow you to say, hey, you missed 3 board meetings, you're no longer on the board. But that's kind of rare. Huh?
Is that easy to append, to add in that rule and have it recorded?
Again, it's not a rule, it's going to be a bylaw, and that's an amendment process that requires membership approval, and you know how hard that is to get. Go ahead, yes.
Does that same apply to if they do show up but are completely silent?
You know what? They have, here's a good one. Here's a good test. Thanks, Scott. When you don't like the vote, okay, you can vote yes or no, and you don't like it, what's going on. You say, well, I'm just going to abstain. I don't agree. I hate this thing. You know, I don't like that roofer. I don't want to hire him. I'm going to vote no. I'm just going to abstain. What should they do? Abstain or vote no? How many people say abstain? Raise your hand. How many people say no? The no's win. It's important that if you don't want a vote to go through, or you want it to go through, but everybody's voting against you, it's important you have your voice heard, and it goes on the minutes that you voted no or you voted yes. Abstention means, guess what? Whatever they say is okay with me. That's what an abstention means. I'm seeing Scott watching the clock here, so I will keep moving. Okay. Okay, all right. I want to keep moving in. Upholding your duties provides protection, and we talked about that already, and that is if you follow your duty of care and your duty of loyalty, you're protected under the statutes and by law. There's the business judgment rule. We talked about it a few minutes ago. You act in good faith in the best interest of the association. Perform reasonable inquiry. Get your experts involved. Ask questions. Sometimes I can't believe the board. Well, where was the leak? Where's this or where's that? And I'm like, go ask the homeowner. You know, it's as simple as that sometimes. You need to get the information. Just facts sometimes there's what missing because your expert can't answer the question unless you gather the facts. And act as a reasonable, prudent person. Okay, it's raining. Get the roof fixed. Financial responsibilities. This is your duty as the board, and your financial folks are going to talk to you about it. You need to follow your reserve studies. You need to have reserves so that you can pay for things in the future. How many of them? A lot of associations don't have sufficient reserves. I get it. There's just not enough money in the bucket to pay for things in the future, but up your dues so you can start getting monies into the bucket. Okay? That is your duty, to be able to pay for the things that need to be fixed. You as a board have a duty to make sure that your properties are being maintained. Are you breaching your fiduciary duty if you don't do that? Absolutely. I have an association that is just mind-boggling. They're not paying any of the bills. They're not fixing anything. They just say, well, we can't up the dues. We don't have any more money. Just let the roofs leak. What's going to happen tomorrow? The lawsuit. It's guaranteed. So it's your fiduciary, and the board members have personal liability because they chose not to do it. Remember, when I'm talking the shield, this is not only to protect the association from lawsuits, it's protect you individually from lawsuits. And that gets back to the point, if you vote for yes or you vote for no, make your voice heard, make sure it's in the minutes that that was your vote. That's important. That protects you. It shows that you exercised your best business judgment. Okay?
I have a quick question about
Sure.
the reserves. I hope this is the right time to ask, but say you have a big reserve and then you're redoing the roofs, and so your reserve goes down. Are you in any kind of, is that okay, like, for when the house is gonna be sold, or?
Well, your reserve gentleman's going to be talking about these requirements today.
Okay, okay.
But generally speaking, if you're doing what you're supposed to be doing, you're paying for roof repairs and your reserves go down, then yeah, you're doing what you're supposed to be doing. The issue then becomes, did you not reserve quite enough, and now the next roof that needs done, you don't have the money to do that. That becomes your fiduciary responsibility to plan for that. Okay, a lot of people go, oh, we're in Southern California, we haven't had rains for the last 15 years, we're not going to get any more rains, now look where we're at, okay? I know a lot of associations are there, and you guys are, for the most part, I see a lot of great boards. They're working hard. Yes, they didn't quite reserve enough money, and they're trying to face some hard issues and hard questions. How do we fund it this year? It's hard, I get it. And talk to your legal counsel, talk with your management, talk to your reserve guys. There's options out there. They may not be easy ones, and you're going to have to up assessments, but keep talking with people, getting your information, working on it.
Is anyone going to discuss SB 326, the balconies?
The balconies, we can hit on it quickly. We're at, by the January here of next year, everybody has to be in compliance with the balcony statute. That basically says that if you have a wood structural balcony, in other words, it could be stucco, but it's your basic structural framing in your building is wood, okay? You have to have these inspected and get an all clearance from an engineer, and I'm being very surface with this right now, okay? I'm just giving you some basics. And you have to have a clearance from your engineer that these are in good condition. And there's no life safety, there's no chance that somebody's going to hurt themselves, it's going to fall down. All this came about before the towers in Florida fell down. So in California, this came about because we had some balconies and decks where people were really hurt because an association didn't stay on top of this. Okay, is it cheap to get this inspection, to get this clearance? No. Is it fraught with problems? Yeah, because once you get the inspection, and if you have decks that need to be done, you only have time to get them done in a very short window of time. If you get red tagged, the city's going to come in and require that get done. Where are you going to find that kind of money to rebuild 10 decks within 30 days? Okay, that's why everybody had a lot of time. This came into play 4 years ago, and everybody's had time to get their engineering, to plan for which decks had to be repaired. I have some associations that were repairing decks all the way along, and here we are into the final phase, and I said, well, you're great. They go, no, we never got reports. They didn't do the report. Once you get your report, you're good for 9 years. You don't have to do it again for 9 years. Okay, so the problem was they were doing decks all this time thinking they were building up to the deadline here, but they didn't have the reports to go with it to say we're good. So now they're having to go back, and there are some decks after 5 years are having to be redone again. So it's still costing them money. So get on your decks, talk to your management company, talk to your reserve people, get on top of those if you have decks. Oops, did I miss something? Enforcement. you have a duty to enforce the CC&Rs and your governing documents. This is one of my big bugaboos. I see boards drafting rules and regulations, and they say, oh, this is good. We need these pet rules. We need these parking rules. We need noise rules. We need, nobody should be out partying in the garages after 10 o'clock at night type rules, okay? And then it starts happening. And the board goes, well, this is a neighbor-to-neighbor dispute, that they're partying in the garage and it's irritating the neighbors. No, you have a rule on that piece of paper that says they can't be done. Don't put a rule that you're not willing to enforce, okay? So when you write rules, I know people say, oh, we need a rule for this, we need a rule for that. Don't forget, you're gonna have to enforce that rule if you write it. You have to faithfully enforce your rules and do so conscientiously and equally. Scott mentioned the new case law out there, email, the right to, and I call it email communications. It's actually a bunch of the people, board members get together at the pool and start talking about, hey, we got roof leaks. What do you think we should do? What about reserve this? What about this? Can they do that? Absolutely. Can they do it on emails? Absolutely. That's the new case. A bunch of the board members had functioned outside of a board meeting. This is the quote right from the case. This is great. You can't take board action outside of a board meeting, but you can discuss what action might you take. Well, what about this or what about that? And Scott touched on some of this on how to run your effective board meeting. I can't say it enough. Prepare, prepare, prepare. People that just pile everything into a board pack and the board doesn't read anything, doesn't know anything until the minute they sit down at a board meeting and pull the board pack either up on the table because they carried it in with them, or management hands it to them because they forgot theirs, okay? You're not prepared. You don't have time to read and analyze a board pack at a board meeting. You need to do that beforehand. I know firsthand, I sit on my board. I am the worst board member. I guarantee you I am, because I'm practicing law, all right? And I have to give myself, probably a good 2 hours, 2-3 hours. You tell me if this makes sense, to prep and read that board pack to make sure I know what's coming before the board at the meeting and can make informed decisions or ask questions. So prepare, prepare, prepare. Do it, please. If you have to have working sessions, and I'm so happy the law has now been made, it's been made open to us to have working sessions between meetings. It's so important because you can go through documents. Hey, we need more information. There's somebody here that asked a question. Well, can we, if we just wait and get some more information and then do it later after the meeting, after we get the additional information? Beforehand, it was, you have to table, it's still the same, you'd have to table and go on. However, if you prepared in advance and had some working sessions and emailed your fellow board persons and said, I need more information, emailed management, I need more information, you'd be prepared to do that vote at the meeting, right? So this is a great tool. Use it. Start your meetings on time. This is not a social hour. How many people have they're sitting there waiting and Sally walks in. Oh, hi, Sally. How's your son? Did he get his car fixed? How's the new baby? I went and saw this great movie. Okay, we've all been to board meetings like that, right? That's not start. Scott's been a great example today of, okay, we got a few minutes, let's get this done, 3 minutes, let's keep on. Whoever your board president is or chairperson, that person needs to be a good, strong leader and keep watch on that clock. Your manager can help you with that too, and I bet you they are, probing you. Come on, guys, we got to get done. Time's running, So make sure you start on time. It's not a social hour. A concise agenda. And I know your management company does a great job on agendas, but if you're doing working sessions, you can help make that agenda even better because you did some emails, you knew this stuff was coming up, you've asked management to add that information so you guys are ready, okay? Stick to your agenda. Don't get off on tangents. That's the board president's or chair, whoever's chairing the meeting, to make sure you stick to your agenda. Do it. Okay, I just did it 3 times here today already where I got off topic, right? Stick to your agenda, stay on schedule, okay? Have meeting rules. You know, put just some general meeting rules so that we follow this kind, motion made, seconded, you do a general, Robert's Rules of Order for small gathering, for small associations. Use it. Have in your rules, you know, decorum. Don't speak over the top of each other. That happens a lot at meetings, doesn't it? So think about getting some rules together. Also, have people sign in, homeowner forum when they walk in, right? Have them sign in, get their name, get their address. And one, it documents who's there at the meeting, but 2, it gives you that piece of paper then to say, okay, John, this is your turn to talk during homeowner forum, you got 3 minutes. People want to talk and socialize. Oh, and by the way, I thought about this, and I thought about, Joe, you only have 3 minutes. Get to your point, okay? This is a business meeting. This is not social. This is not some time for them to give a grocery list of things that they wanted to air and talk about. If they could get 3 minutes, maybe could. This is the time where you say, look, if you have a bunch of stuff that you want to take, you know, bring to management's attention or ours, email it to us during the month. Send us a piece of paper. Or today, write it down and hand it into the board, and we now will have all this stuff looked at and ready to talk or answer to you sometime during the month or maybe at the next board meeting. Get efficient. Documentation after the meeting. This is really important for your minutes. You know, make sure you have good minutes. Make sure you follow up. Somebody asked about the minute availability. Minutes must be made available, okay, within 30 days to the homeowner, whether or not the board has adopted them and finished them. Okay? That's scary, isn't it? There could be mistakes in those things, but because you're not making quorum at the next board meeting, you're now out 60 days. Sorry, you don't get a bye. The statute says they must be made available to homeowners even if they're not finished in 30 days. So if I were you guys, you know, work on getting these things put together and done, and make sure at the end of the meeting your motions were made correctly. How many of you make motions and then next month go back and say, well, did we really say that? Okay. Have the motion read back. I make a motion that we do blank, 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 blank. I'll verify. Did we agree to number 2 or not? Read it back. Again, we talk about homeowner forum, limiting your time. The chair needs to be the leader. Just because you're board president doesn't necessarily mean you would be a good person to run meetings. Not everybody could be a good, you know, chair a meeting and keep it organized, efficient, watch the clock, have the guts to shut somebody up and say, you know, we're really running out of time. You can always do it nice, but not everybody has those skills. Just because you're president, you may be a great president, but you don't run a meeting well. Hand it off to somebody who can run a good meeting. There's nothing wrong with that. Everybody has different skill sets, okay? It doesn't have to be your president. Typically it is. Everybody thinks that, but it doesn't have to be. You can hand off to somebody that can do it well. Make sure motions are clear and voted on. And then again, back to good minute taking. I don't like board members, and Scott, chew me out if you don't want me to say this, but I don't like board members taking minutes because you can't make decisions and listen and negotiate and talk about stuff if you're busy making minutes. I don't care if you make your own notes, but there's a problem with a board member trying to take minutes because they're too busy trying to keep track of the communication, the points that are being made, the documentation, and not actually participating in the decision-making process. But that's my thing. Conflict resolution. You asked, what's the difference between ADR and IDR? IDR and ADR. IDR is internal dispute resolution. It's your meet and confers. Have everybody heard those terms bantered around? Meet and confer with the homeowner? That's where you use IDR. There's a whole statute section saying these are the things that if you have an IDR rule or set of rules on how you will run your IDRs, you must have these things. Most people don't. They go back to the default, and that basically is you have to have a written request by a party. The association cannot refuse to participate in a meet and confer. A homeowner calls you up and says, I want to meet and confer about such and such. You have to do it. You don't have a choice. You could say, oh, this is stupid. We don't want to do it. No, you have to do it. If you're in a conflict with the homeowner and you ask the homeowner to attend a meet and confer because you want to work through a problem with the homeowner, does the homeowner mandatorily have to participate? No, but you do. Okay? So don't forget that. You have to meet promptly at a mutually convenient time and place. If a homeowner says, I want to meet on Tuesday night, oh, let's see, Saturday, I want to meet Tuesday night. Well, okay, how are you going to get this notice out to the board members and get this all arranged by Tuesday night, this coming Tuesday? That's not very reasonable, is it? It's not something that you can conveniently organize. On the other hand, if you say, well, we only meet every other month, and we already had an April meeting, so we're not going to meet now till June. Is that reasonable? No. You have to schedule it, period, end of story. And I have a lot of boards that try to say, well, I can't get my board together. We only meet quarterly or we meet every other month, and I can't get them together, and they won't do it, meet and confer. My answer to them, okay, you're in violation of statute. And what is that going to cost you? What happens to you? Well, you're going to piss off the homeowner. He's going to go hire an attorney. It could get really bad, or it could just go away. I can't tell you. But you don't want to violate statute. You need to meet your fiduciary duties, right? We're back to fiduciary duty here. And when somebody asks for a meet and confer, you need to reasonably set up a time that's convenient for both parties. Okay? In my rule sections, like rule violations, when we set up meet and confers with homeowners, I automatically make sure that there's a 10 to a 15-day, depending on the type of violation, notice to the homeowner saying this is when we're going to hold this hearing or this meeting. Okay? So if in fact your next board meeting, executive session, is 10 or 15 days from now and you send out the letter to now, that's a reasonable time to do it, isn't it? If the homeowner says, no, I can't make that meeting, you'll have to bump it out. But you set it up, you go for it, you try it, and if the homeowner says, I can't make it, then you'll have to try again. You got to meet and confer in good faith. You can't come into the meeting, pre-decide we're not going to do this. We're not going to give him a parking place. Because you don't know what that homeowner is coming in asking for that parking place about. He may need an accommodation for disability. He may need that parking place only for 6 months because he's got a major water flood in his house and he's got to put everything into the garage. And he can't park in the garage, so he needs to park out. So don't be preconceived notion that we're not going to grant the request. We know what this person wants. It's go in good faith and try to find a resolution. Even with the most difficult homeowner, be creative. Try to find a resolution. It may not be what makes him happy. It may not make you 100% happy, but you're looking for something that'll resolve the dispute. An attorney can attend on behalf of either party. If a party says, I don't feel comfortable doing this meet and confer, I want Sally to go for me. Does Sally know enough about what's going on? Hopefully he does, but they could have somebody either go for them and attend this or come with them and hold their hand. Same with you guys, okay? If you want your financial person there, you want your management person there, you want your attorney there, that's okay, and they can do that as well. This second requirement, resolution dispute agreement, needs to be in writing. People read the code and they think, okay, we have to come to a settlement decision. You have to put it in writing. No, you don't. If you come up with a resolution, a means of resolving the dispute, that must be in writing, and both parties must sign it. But if you don't come up to a resolution, you can't get to an agreement. There's no requirement that you do. And then finally, members may not be charged. Let me finish this one real quick. We do a meet and confer with a homeowner about their assessment account, right? And then they say, okay, well, the attorney was present, and so we need to put that fee on the assessment account and charge the homeowner that. You can't charge for it. Let's talk about the next level. This is done in an informal process. You just set up a meet and confer with your board members and the homeowner to try to resolve a dispute. Okay, this is more informal. The next process that we escalate to an ADR, which is alternative dispute resolution. That can either be a mediation or an arbitration. This is where you get an independent third party to act as a mediator or an arbitrator. This is where we take the matter to a higher level of legal involvement, and you go to a mediation or arbitration company like JAMS, Judicate West, AAA, like you remember if you've done construction work or contract work, a lot of times you'll see a mediation paragraph in the contract that says we agree to use AAA as our mediation arbitration company. Well, that's in the industry that we work with. We see a lot of Judicate West, JAMS. I can't remember some of the others right now. So those folks, you go to them and you say, we need to do an ADR. Give us either a retired judge or a professional mediator or arbitrator, and we're going to hire you guys to run a mediation or arbitration. Does everybody know the difference between a mediation and arbitration? Okay, you don't. Mediation is like a settlement conference. Like when you have labor disputes and you have people coming in between the two sides trying to mediate and make them come to a resolution, like the baseball strikes. Okay, that's what a mediation is. It's a settlement discussion. You have a mediator that tells you, your case is terrible, you need to settle. And then he goes into the next room and says, your case is terrible, you need to settle. And they try to bring the two parties together and resolve a dispute. Okay? Arbitration is like a mini trial. You have an arbitrator that's actually going to make a decision. They don't care if you settle the case. This person, the arbitrator, is going to hear the evidence, the law, and then render a decision. Sometimes those arbitrators' decisions could be binding. That means you can't go to court afterwards. It becomes a binding agreement that can be enforced by a judge. But most of the time arbitrations are non-binding, which means it's kind of like they get a first bite at the apple. We're going to try our case with an arbitrator and just see if we win maybe. See how good our case is. I don't like arbitrations for that purpose because it is like a trial run, you know, first bite at the apple, but if I don't like it, I can still go to court. It wastes a lot of money. If you have a very difficult case that you're not sure you can or can't win and you want to flesh out your case and you have a lot of money to do it, arbitration might be a good idea. This is my opinion. There's other attorneys may have other opinions, but I'm really not a big fan of arbitration. Mediation, absolutely, because I think about 75% of the cases, if not more, are solved in a mediation because people have to put money out to pay for the mediator and be there, and the mediator is trying to make parties settle the case, and it really works. Oops, wait a minute. To do a request for ADR, you have to put it in writing, okay? You have to give a brief description of the dispute, just like like you would do like a complaint, like, well, you're parking in violation of rule such and such. That's a brief description of the dispute, and you are not moving your car, okay? A request for ADR and a notice that they have to reply in 30 days. The interesting thing about IDR and ADR, if you don't participate in ADR, if you go to court, even if you win your case, you may still owe the other side their attorney's fees because you refused to participate in ADR. Okay? Also, it is required by statute that you first go through the ADR process before you get to file your lawsuit, unless you're looking for injunctive action only. So if you're looking for attorney's fees and damages, you must go through the ADR process before you file the lawsuit, unless there's an emergency. And if you fail to, the judge can dismiss your case and say, I'm dismissing, you just spent all this money drafting a complaint and filing your case, but I'm dismissing it. You just spent all this attorney's fees, because you have to go back and do ADR. And if you don't settle it in ADR, then you can come back and file again. So when your attorney says, oh, well, I'm sorry, we have to do ADR first, we can't just go and sue this guy. Now you know why, because the statute requires that step. Okay? best practices. I've changed this list over the years, and Scott, you might add to it. Be familiar with your governing documents. I'm not saying that you need to memorize them, and because that's really, really hard to know every little detail in your CC&Rs. Like I said, I sit on my own board, and I have a general concept, but I sit there with them at board meetings, flipping back through them too, just to see what's in them. So try to be familiar with them. If you're enforcing parking rules, be very familiar with your parking rules, okay? Be transparent, use good communication skills. All right, the lawyer I am is going to say, be transparent except when you have an attorney-client relationship privilege where you're having to keep certain confidential information because the attorney told you to, okay? Otherwise, be transparent. Always act in the best interest of the association. I'm sorry to keep beating this dead horse, but you do it. It's really important. You might say, I hate trees, but is it in the best interest? You're in this beautiful garden association, Garden Homes Homeowners Association, and you have all these beautiful trees. Just because you hate trees doesn't mean you go cutting all the trees down. That's not in the best interest of the community necessarily. You can cut trees down that need to be cut down, cut trees down that are causing damage to property. Okay. Avoid conflicts of interest. We talked about that. Avoid even the specter of a conflict. If you're not sure that there might be a conflict, be transparent, discuss it, open, tell everybody what's going on, then back off and recuse yourself from the voting process. Make inquiry and seek advice of professionals. Absolutely critical. Your board members, we all think we know more than we know because we all surf on YouTube. I can do brain surgery now. And we all think that, and I laugh because I do the same thing, right? We all do. But as board members, you got to stop yourselves and say, I'm not a tree specialist, I'm not a painting specialist, I'm not a roofer. I think I know a lot about roof. I might even be, I know a lot about roofing right now as a lawyer because I deal a lot of lawsuits about roofing. But I'm still not a roofer. I'm going to go to a consultant and ask their expert opinion. You guys absolutely should, okay? Be fiscally responsible. Get those dues up, okay? Make sure you have enough money to do what you need to do. Just because you don't want to raise the dues doesn't mean I get it. But if you have deferred maintenance and you don't have enough money in reserves, banks are not going to lend to homeowners in your community who want to buy homes. Homes won't sell. You are now in breach of your fiduciary duty because you weren't fiscally responsible. Scott can answer to that because he's in the real estate industry as well, and he knows that lending is getting tight, requiring the Fannie Mae, Freddie Mac.
We're looking at the financials now, Fannie and Freddie.
Yep, and there's a questionnaire here, and you answer that questionnaire, and it says, do you have deferred maintenance? Yeah, we didn't paint in the last 10 years, and our paint's coming off, or we didn't do our roofs, or we didn't do our fences. Do you have adequate reserves? No, we know we're underfunded significantly, not just by numbers and paper. We know we don't have enough money to do the paint job. We know we don't have enough money to do the roof, to do the decks. So you need to be fiscally responsible because that ultimately could hurt your homeowners because they can't sell their homes